Hello everyone, welcome to part 3 recording of non-fatal offences and related defences. So in the previous 2 parts we covered areas of non-fatal offences and looked at assault, battery, ABH, GBH and wounding. What I'm going to do before I move on to the defences, I'm just going to have a quick recap of non-fatal offences and some key points. Some of you have been asking me questions relating to these, so I thought it'd be a good opportunity to recap as a whole. So assault and battery are both summary offences, and these can be tried together or separately. And remember, together they are known as common assault. They are different offences, however. An assault relates to anything that causes fear. Remember we looked at wording, actions or maybe inaction, anything that could cause a victim to fear. Battery is the more physical offence which relates to application of force. And remember that application can be slight. And because these are summary offences, we're looking at no injury or temporary symptoms of fear or distress. Both require mens rea, and as I said on the previous part, don't forget to apply the mens rea elements. So we need intention or recklessness to either cause fear or to apply force. If the assault or battery causes higher level injuries, then this could be charged as an actual bodily harm offence, which is found under the Offences Against the Persons Act, section 47. So because the injury is greater, this is actually a triable either way offence. It's quite wide ranging, so could be tried in the Crown Court if the injuries are greater, like a loss of consciousness or a broken nose or broken bone, for example. So remember, ABH is an actus reus level offence. So the assault or battery that causes the actual bodily harm, we're establishing what the injury is and whether that injury has been caused by fear. Some of you have looked at the Sandra and Tara scenario, and I have identified where Sandra makes Tara jump and she falls back and hits her head. That would be a fear, so an assault, but the injury she suffered from hitting her head against the wall is severe bruising. So that would be charged as an assault which has caused or occasioned actual bodily harm. In relation to the mens rea, Sandra doesn't need to have intended to have caused those level injuries, so the severe bruising. All she needs to have done was if intended or been reckless as to causing Tara to fear. So the mens rea stays the same. So think about ABH as an added layer, its relation in relation to the injury. So with a battery, for example, if you punched somebody, you might only cause them a reddening to the face, in which case that would be charged as a battery. But if you punched somebody and you broke their nose, then that could then be deemed to be a battery which has caused actual bodily harm, and you could be charged with the higher level offence. You don't need to have intended to have broken the bone, so caused the actual bodily harm. You only need to have intended to apply unlawful force. So I hope that helps. GBH and wounding are the higher level offences, generally tried as indictable offences, but section 20 is actually a triable either way offence, although generally would be tried in the Crown Court indictably. Section 18 being more serious because of the intention to cause serious harm, is an indictable offence, so always tried in the Crown Court. So I've been asked a couple of questions in relation to GBH and wounding. The difference is really academic because both are tried and found within the same sections. So you have GBH or wounding under section 20 or section 18. The difference is purely how the injury has been caused or inflicted. So for a GBH, you're looking at broken bones. A wounding will just be anything where the layers of the skin have been broken, so a stabbing or a shooting, anything where you see there being a substantial or severe loss of blood. So GBH relates to anything else other than that. Obviously, both of these result in serious injuries. The difference that would be the main issue in any scenario would be whether you would charge the GBH or wounding as a section 20 or 18 based on the intention of the defendant. So to apply GBH wounding in a scenario, which we will do in our tutorials this week, you identify first of all, is it a GBH or a wounding injury? And then, does the defendant have intention to cause serious harm, in which case it would be a section 18, or has the defendant only intended to cause some harm? So there's no evidence of specific serious intention there, in which case it would be a section 20. As I say, we'll have an opportunity to apply that in our tutorial. So moving to relevant defences. So these aren't all of the defences that we'll be learning through criminal law. These defences are commonly raised in relation to non-fatal offences, so it makes sense to cover these here. So we will review self-defence, and under that same umbrella, defending another, protecting property, preventing crime, and consent. And it is consent that we are going to look at now. So consent is a full defence, a complete defence, which means if a defendant argues that a victim consented to injury or harm successfully, then they will be fully acquitted. So it's not a partial defence, it is a full defence. There are some limitations to the use of this defence. It can never be used for murder. Hence why we didn't learn it or refer to it when we looked at murder. That comes from the case of Inglis, which you will already be familiar with, the mother who overdosed her son to try and put him out of his misery, because if you remember, he'd been injured quite seriously by falling out of an ambulance and had become disabled. Now she had killed him and had intended to kill him, so the charge was murder, and she had raised that she was doing it out of or with the best intentions, and he would have consented had he have been able to. Both arguments failed. Remember, you don't have to have had malice to kill. You don't have to have that ill will. The intention was there. So consent, you can never consent to murder. Equally, relatably, applies to assisted suicide or euthanasia. You can never consent to somebody helping you to die. Now, we've talked about this before. It's obviously quite a large debatable area. There have been many cases that have gone to the Supreme Court and the European Court of Human Rights to debate this. The more recent cases, you've got Debbie Purdy here. She fought for the right to die, and she was unsuccessful, but actually, in a way, her case was deemed to be a success because it prompted the House of Lords, as it was then, to tell the CPS to draft guidelines of when they would prosecute a loved one for helping somebody to die. And the CPS, under the leadership of Keir Starmer, our now current Labour leader, he was the Director of Public Prosecutions at the time. They drafted guidelines, and essentially since then nobody known has been prosecuted for assisting a loved one to die. So it's deemed not to be in the public interest as a practical point, but it is still illegal, so you cannot consent to be killed. You may remember that after this case, Parliament then tried to pass a law called assisted dying. So it started as a bill in the House of Lords in 2013. It did fail quite early on. I believe it got to the second reading in the House of Lords, so quite early stages, and failed. The courts are just refusing to legalise euthanasia, and they've said it's up to Parliament, and obviously Parliament couldn't agree initially, so at the moment this is still unlawful. It's a good area to talk about in any consent essay, a good paragraph to write about. Consent can't be raised as a defence to injuries where the defendant intended to inflict harm. So where there's intention to inflict harm, you can't raise consent. And the relevant cases here are cases of R.V. Brown and R.V. Emmett, and hopefully you remember these. We looked at these in relation to judicial precedent and compared them to the conflicting case of Wilson. Now, Brown and Emmett, in those cases, both defendants raised consent, but they were unsuccessful because they had inflicted injuries that were really of a serious nature. We're talking top-level ABH and GBH injuries on the victim or victims. So where essentially what these precedents create is a ceiling, a limitation on the ability to raise consent. Anything higher than ABH level, mid-range ABH level, will not be consented to. And rape of a child under 13 can never be consensual. So this case, hopefully remember from our strict liability lesson, this case of RVG, so obviously any children will be anonymised in court proceedings. So the defendant in this case had sexual intercourse with a girl aged 12. He raised consent, but the court rightly said consent is not an issue to be considered. This was a strict liability offence. The case actually went up to the House of Lords as it was then, and Lady Hale, as she is Baroness Hale now, she made some comments about this that I just want to read to you. So the relevant legislation that the defendant was charged under was the Sexual Offences Act 2003, and she commented that this act is designed not only to protect children from paedophilia, but also to prevent children under 13 from engaging in any sexual activity with others. So that's the policy behind the legislation, meaning that the defendant, even though they may have sympathised with the circumstances, the defendant would still need to be guilty. So those are the limitations. Consent can never apply in these instances. If we believe that consent may apply, so we're not ruling it out by the limitations, we then move on to the requirements. So note how I'm teaching this in a particular order. Is consent available? If it is, and it's not limited, then we move on to the requirements. So essentially the requirements are that the consent itself must be real, fully informed, and not obtained fraudulently. So there are a couple of really interesting cases here that illustrate this. So the first one being Tabassum. Now the facts of Tabassum. Tabassum was an ICT lecturer, and he claimed to a number of women. He was only charged of 3 counts here, but they believe there were more victims that didn't come forward. But he claimed to a number of women that he was carrying out research for a hospital and building a database on breast cancer. So what he did was convince them to allow him to carry out physical examinations of their breasts. So when they realised something wasn't right, he was then charged and convicted of 3 counts of sexual assault. He claimed that they had consented to this and, of course, was not successful. So the consent wasn't real, it wasn't fully informed, it wasn't obtained fairly, it was definitely fraudulently. The case of Olibolia also adds to this, to the requirements, and in terms of consent being real, now if you're not consenting, as you will have seen from various adverts and the police campaign about consent, you don't necessarily have to say no to something. But this case, if you note how old it is, the defendant claimed that the victim had consented because they didn't say no or resist to the defendant's action. So I'll just tell you the facts briefly. So in this case, two girls aged 16 and 17 were offered a lift home from a nightclub by Oliabolia's friend. But instead of taking them home, he drove them in the opposite direction to his home. They refused to go in and started to walk off, but actually what happened afterwards was quite worrying and traumatic. He picked up the 16-year-old girl and raped her in his car. He then picked up the other girl, who was still nearby, and took both of them to his home where Olibolia was. Olibolia then took the 17-year-old upstairs and raped her. Now, because she was so fearful and obviously was aware of what had happened to her friend just moments earlier, she did comply. You know, she didn't resist, she didn't struggle, she didn't scream during the rape. And Olibolia took these actions as reasons to justify why he believed that he could raise consent. So luckily, this was unsuccessful, and even on appeal, the Court of Appeal made sure to make clear that there is a difference between consent and mere submission. So the fact that she had submitted to the rape doesn't mean she was consenting, and obviously that is widely known now, especially with the police and other campaigns. You don't have to say anything, you don't have to say no, and this obviously raises some difficulties at times in terms of proof, but an older principle, but definitely still really relevant now. We've got also the case of Dika, which is a later case, and similar case the year after Konzani, if you want to look up Konzani in your own time. So Dika was an interesting case, quite groundbreaking in that it involved transmission of an STD, a sexually transmitted disease, HIV in particular, and this was charged as a grievous bodily harm offence. So that was relatively new. So don't forget that if you see something like that in a scenario, you can identify that. If it's a life-threatening illness, it can be charged as a serious non-fatal offence. So Dika was diagnosed with HIV, and knowing this, he'd had relations with two women and had unprotected sex with both of them. He had reasons that he put forward for doing this, but he was convicted of Section 20, grievous bodily harm. Now, the judge at the trial refused consent to be raised before the jury, as judges can do. It is quite risky because they risk being appealed, and the judge was appealed here, and a retrial was ordered, but Dika was convicted at the retrial anyway. He did appeal based on an old case, a case called Clarence, where Clarence had ruled out transmitting of life-threatening infections as being charged. So you can have a look at that case in your own time. But the Court of Appeal overruled that case and upheld Dika's conviction. They also remarked that had this had been a deliberate infected intention, or intention to infect, then he could have been charged with Section 18. But on the facts, this was certainly some kind of reckless and ignorant and knowing transmission, but not necessarily intending to cause any serious harm. Okay, so requirements, looking at those cases, in summary, you have to identify whether the consent in the scenario has been obtained genuinely. So is it real consent? Does the victim know what they're consenting to? Are they fully informed of all of the facts? If the defendant is trying to dupe the victim in any way, then that will not be successful. There is another case you could look at called Richardson, which involved a dentist who was suspended from practice and still carrying out practice on patients. So have a look at that one and see what the court said about that. There is the link to the news article for the Dika case if you'd like to look at it. Okay, another principle for consent is that you can rely on consent as a defence even if you mistakenly believe it to be so. And if a defendant is mistaken in believing that a victim consents, they may still rely on it even if that belief was unreasonable, as long as it was genuine. So genuine mistaken beliefs could still result in an acquittal. And there's a case, a really important case of Jones and others. So there was a couple of defendants here that were charged with causing quite serious injuries actually to some schoolboys. This was essentially an act of what the courts call horseplay. So the boys at school were mucking around, throwing each other into the air, and two were quite seriously harmed. So the boys who had tossed the youths up into the air were convicted initially of the injuries, but their convictions were quashed on appeal, and that's because they had genuinely but mistakenly believed that the victims were consenting to rough play, and this was deemed to be a defence. Okay, so we've got our requirements, but then we have also instances where we could imply consent. So instances where consent can be inferred automatically. So let's have a look at those. So if we have a scenario where we have the defendant and victim engaging in a contact sports or game, then consent to injury or harm could be implied there. So we'll have a look at the rules in a minute for that, because that's quite a commonly examined area. Surgery, consent can be implied. Now sometimes hospitals or doctors will ask you to sign something to consent, so specific consent, but certainly for emergency procedures, consent will be implied if it can't be obtained. Horseplay, so as you saw with the previous slide, the case of Jones and others, horseplay, even if rough, can be consent can be implied. Reasonable punishment or chastisement of children, so this is quite a complex area, because of course over the years reasonable punishment or ideas of reasonable punishment has changed. So 50 years ago that would be very different to what we believe now, and actually when I was in practice I did represent a client who had smacked his stepdaughter on her thigh so hard that he left red marks. Now it could be that courts may deem a smack as a reasonable punishment, but if a smack is so hard that it leaves red marks significantly for days, and these are picked up by somebody else as they were in that case, then that would be deemed not to be reasonable punishment. So it's a very grey area, as many of these are unlikely to come up in an A-level scenario, certainly. Tattooing, so consent can be implied there. Of course, age restrictions apply. And this could be extended to branding. So if you think about the case of Wilson, where he branded his wife with a W on her buttock, and she had asked for him to do that, and he was able to successfully rely on consent. Ear piercing as well, and touching people in a crowd. Now, Wilson and Pringle, if you look at the citation here, this was actually a civil case, a tort of trespass to the person. So this was a case involving a claim for compensation. Similarly to Jones and others, this case involved some schoolboys who, again, were messing around at school, the horseplay style that the courts refer to. Pringle fell and was injured, but in the end Wilson wasn't liable. So this went up to the Court of Appeal, hence why the citation has changed. But Wilson wasn't liable because the court said although his actions could have been argued as a battery, so there was application of force there, there wasn't any intention because they were messing around. There was no hostility between the two boys, and therefore criminal principles for the offence of battery do transport to the civil offence. Now, we on the A level don't learn about trespass to the person, so you don't need to worry about that, but that is a civil area where if somebody inflicts harm or causes harm, so a non-fatal offence against you, you could claim for compensation in the civil courts for that. Okay, so these are instances where consent can be implied. If you can highlight the contact games and sports, the surgery, the horseplay, and branding, those are the more common areas that you would see in a scenario. So sports, let's just go through the law of sports briefly. So there are two key cases that you need to know. So you've got the case of Barnes, decided in 2004. So this was where Barnes made a late tackle on a victim during an amateur football match. The victim suffered a serious leg injury. So Barnes was initially convicted of causing that serious leg injury, but his conviction was quashed. And what the Court of Appeal said was that where an injury is caused during a match, so please underline during a match, a criminal prosecution should be reserved for those situations where the conduct was sufficiently grave. Now, we've talked about the word grave before, if you remember, with voluntary manslaughter, grave circumstances. This means serious. So you should only be prosecuted where the conduct was sufficiently serious. And it's interesting with football cases, those of you who are football fans, you'll remember there have been incidents of biting and whatnot, headbutting, where the player does not face criminal prosecutions in court and is dealt with internally by the FA, and that's largely down to this principle, this case. Only if the conduct is deemed sufficiently serious would somebody be charged criminally and taken through the courts. Billinghurst, although earlier case, is a really good case to contrast because this was a rugby match and involved a punch in an off-the-ball incident. So the difference between the two is that one injury was caused on the ball, so during a match for Barnes, and for Billinghurst the injury was caused off the ball, so where the players aren't expected to be engaging in any conduct at all. Billinghurst was convicted of the serious injury and conviction upheld. So the key thing to be looking out for as to whether consent could apply in a sports incident would be if the injury was caused during play or outside of play. So please do make sure you summarise that. Horseplay, again, a common area that I asked you to underline. And Jones and others is the key case for horseplay. There is a later case of Aitken and others if you wanted to look at that, and this was serious injuries, serious burns were caused during an initiation ceremony into the RAF, and horseplay was deemed to be a relevant and available defence here as well. So horseplay can be really rough, and it's based on a genuine belief that is not necessarily reasonable. So just keep an eye out for that. If you see a scenario where two friends are messing around and one gets injured, horseplay is probably going to be considered here, and consent would be successful. Okay, so practice question. There is a potential area of consent here that you could consider. If you have a look at the top in the green, this is part of a scenario that I've taken. There are many more application scenarios, so I will be setting you some to practice, and I'll do that after this week. So once you've watched this session and we've had our tutorials. So just after the ball had gone out of play during a football match, Anna tackled Beth very forcefully. The tackle bruised Beth's leg. So let's have a think about this. Is consent available to Anna for the bruising to Beth's leg? What is the charge? So you can pause this and have a think yourselves. So the charge here with the tackle causing bruising is probably going to be a battery causing actual bodily harm for bruising. Now, the relevant part of this scenario is that the ball had gone out of play. So although the bruising has occurred during a sports event, the fact that this is an off-the-ball incident, go back to the two key cases, which one is going to apply, and will Anna therefore be guilty of causing that bruising? So if you pause that and have a think, and the relevant case would be Billinghurst, and Anna would most likely be liable purely because the ball has gone out of play. But then what happens is there's a second knock-on incident. This causes Beth to fall onto Charlie, a 4-year-old boy who was riding a bicycle by the side of the pitch. Charlie's head struck his handlebars and he suffered a long, deep cut to his face. A long, deep cut. Descriptive words like deep would indicate a high-level offence. So this is going to be a wounding. I hope you've identified that. And the issue is whether Anna has caused that wounding. Now, she's essentially not got any intention to cause the 4-year-old boy, Charlie, any harm. But obviously, if we think about the actus reus first, her actions have caused Beth to fall onto Charlie. So she's caused the deep cut to his face. So the actus reus would be satisfied. She's caused the wounding. But the issue of intention, we could use transferred malice to transfer the mens rea. But is this going to be a section 20 or section 18? This is probably going to be a section 20. There isn't intention to cause that serious injury. There just isn't. This is a knock-on effect of events. So she will be guilty of ABH to Beth and wounding to Charlie, and consent will not apply here. What we have in the red part is a final incident where we're not going to have consent here. This is just about an argument later. So have a look at that and let me know in the tutorial what you think about that incident. So we're now going to cover self-defence, and these same requirements can apply to defending another, defending property, and acting in the prevention of crime. So self-defence traditionally was a common law defence, but it's been codified in the Criminal Justice and Immigration Act 2008. It came into force in 2009, and you'll find the requirements under section 76. So you can use force to lawfully defend yourself, defend another or property, as long as that force is reasonable and you are honestly trying to protect yourself or another or property or prevent crime. You can rely on the defence if your belief is mistaken, but it must be genuine. See, there's a bit of a theme there. And you cannot calculate the amount of force used. So essentially you can't think about it. It has to be a genuine response to an attack. So these are the requirements, the main one being that you must use reasonable force. And this comes from common law, where the defence pretty much originated for, which was the case of Beckford. Hopefully you remember this case, the Jamaican police officer who shot at somebody believing they were armed and they weren't, and he was able to rely on the defence mistakenly but genuinely. So in terms of whether you've acted reasonably, in court a jury would be asked to judge the defendant's actions based on what the reactions of a reasonable person would be. So this is objective, but also clarified by the case of Palmer. You would also judge the defendant's actions on what they believed at the time too. So there's kind of a two-stage test there for the judging of reasonable force. Of course, the issue is that everybody would have different or varying ideas of what reasonable might be. But we do have two cases we've looked at before where the courts have deemed the defendants to use excessive force. One being the famous Tony Martin case, the shooting of the burglar in Norfolk. The other one being Clegg, the soldier who shot at a car going through the checkpoint and killed one of the passengers. So both were deemed to have used excessive force. So force reasonable. Force can be mistaken, or belief in using force or needing to use force can be mistaken. Again, that comes from Beckford. He was mistaken in his belief that the victim was armed, but he was still able to rely on the defence. However, if your mistake is due to you being intoxicated at the time, you cannot rely on the defence, and that comes from an old case of O'Grady. Now, quite interesting facts here. O'Grady was an alcoholic and had spent the day drinking with a couple of friends. They all went back to his house and fell asleep, and what he claimed was that he was woken up by one of them hitting him on the head. He picked up some broken glass and started trying to defend himself with his words and hitting the victim. Now, the next morning, sober, he woke up and found his friend dead. His friend was significantly injured, 20 wounds to his face, substantial loss of blood, severe bruising to his head, brain, neck, chest, a fractured spine caused by his head being forced backwards, and unsurprisingly, he was convicted of killing his friend. Manslaughter was the charge in the end, but he did raise self-defence, claimed he was trying to defend himself, And although that was potentially mistaken because he was intoxicated, the court said you cannot rely on mistaken belief if that mistake is due to intoxication. And actually that has been updated, if you can add this to your summary notes, in the Criminal Justice and Immigration Act, section 76, subsection 5. You should look at the legislation and look at the order that I've given you and plot those against the subsections under section 76. So this slide is a reminder of excessive force and the facts. Now, Tony Martin, we've obviously covered quite a bit, and this was quite a really high profile case where he was unsuccessful in raising self-defence at trial, but many high profile cases led to the Conservative government reviewing this area and amending the concept of reasonable force from the Criminal Justice and Immigration Act in relation to homeowners. So there's an amendment that you can find in section 43 of the Crime and Courts Act 2013, which gives homeowners more protection to defend their property. So where you are a homeowner, what the law says essentially is that you may be acquitted and entitled to rely on the full defence of self-defence where you use disproportionate force. And that's because you believe it to be necessary, so the other requirements still count. But if you use grossly disproportionate force, then you will still not be able to use the defence. So note that we've got a few more terms added here. So obviously under the Criminal Justice and Immigration Act, there's talk about using reasonable force. But if you're a homeowner, in the Crime and Courts Act, they then talk about how you can use disproportionate force, but not grossly disproportionate force. Now we've talked in class about the use of reasonable force as being proportionate. It makes sense to compare. So if you're being attacked with a knife, for example, attacking back with a knife could be deemed to be proportionate and therefore reasonable, I suppose, legally. But if you're attacked by somebody without a weapon and then you use a weapon, that would be disproportionate and therefore unreasonable. So you can see why the use of the word disproportionate has been added, but what it does is just makes this area a bit more vague and open to interpretation, which could lead to some uncertainty in cases. So definitely an area for evaluation. So in summary, just make sure that you are aware that homeowners are given a bit more protection to defend their property now. There are instances where a court may decide whether it was necessary for somebody to defend themselves or could they have walked away. And they considered this point in the case of Bird. So this was, again, an interesting case. A 17-year-old girl was throwing a party for her birthday, her 17th birthday. Her ex-boyfriend turned up with his new girlfriend. An argument developed and she asked him to leave. He did leave but then returned later and things became more heated. She poured a drink over him. He slapped her and pinned her against a wall, to which then she responded by punching him in the face with a glass in her hand. She claimed during trial that she forgot she had the glass in her hand at the time. He ended up losing an eye, so this was serious injury here. So she was charged with section 20 wounding, so based on causing that serious injury, but no intention to cause that serious injury at the time. She raised self-defence. Now, she was convicted at trial because the judge had directed the jury and mentioned that there was no willingness by her to retreat from the situation. So she had stayed and fought unnecessarily, essentially. But on appeal, her conviction was actually quashed. And what the court said was, the Court of Appeal here, there is no legal obligation to demonstrate a willingness to retreat. All that does is serves as evidence that you acted reasonably and therefore would be more likely to be successful. So you should retreat if you are able to do so. It's the best evidence that a defendant was acting reasonably and in good faith. Okay, so defending another and defending property, these two defences, of course, you still would need to decide whether the defendants used reasonable force, but these two defences come from these cases here. So you've got the case of Duffy, and if you read the paragraph I've got here, the court held that Duffy was justified in using reasonable force in order to defend her sister, not because they were sisters, but because there is a general liberty as between strangers to prevent a felony. We don't really use the term felony anymore. But what this is kind of telling us is that you could use reasonable force to defend anybody, could be a stranger. And you can use reasonable force to protect property, and that originally comes from Hussey. So Hussey had fired a gun through a hole in the door, which was made by his landlady, who was attempting wrongly to evict him from his home. She was injured. So he was using force to protect his property. Kind of similar to the Revel and Newbury case that we've looked at before. If you remember, he was acquitted of wounding at trial as well. So these cases are illustrations to use for defending another and defending property. And then we have the relevant legislation for preventing crime. So a person may use such force as is reasonable in the circumstances to prevent crime, or in effecting or assisting in the lawful arrest of offenders or suspected offenders or persons unlawfully at large. So just note the use of force needing to be reasonable. So if you're acting to prevent crime here, if you're seeing somebody being mugged in the street, then of course you can use reasonable force. If you're trying to apprehend somebody, so if somebody's run out of a shop, they've just committed theft, you could assist in the lawful arrest of them. Or if you see somebody who is at large, so they're on the run, you could assist in the apprehension. Of course, the police will often say that the public shouldn't be involved in things like that, but you can use lawful force by this piece of legislation legally. So that comes from Section 3 of the Criminal Law Act 1967. These areas very rarely are assessed on a scenario. It tends to be self-defence rather than defending another, preventing crime. But it has come up before, so I'll find some for you to practice. Okay, so that is the relevant defences. So we've covered the law relating to non-fatal offences and the related defences areas now. So do take some time to write these up, and there are some more tasks in your booklets that you will need to complete from the daily planner. What we need to do next will be practice these areas in scenarios, so application practice, and as much as you can do will help you. There will be loads online as well. And then we need to cover the evaluation of each of these areas. So non-fatal offences, which is quite a common essay. Consent. Now consent was the very first essay that was assessed in 2019. So I actually have lots of information and really good student answers on that, and there will be the mark scheme online for that. Self-defence could also be an essay as well, the criticisms and the issues with self-defence. So we're going to have a look at these areas over the next week or so before we move on to property. Thank you for listening. Hope you found it useful.